Monday, just before midnight, the state of Texas filed a lawsuit that they are saying now is more important than all of the others surrounding the presidential election. Texas brought a suit against 4 states that they say did something that they can't do. They violated the Constitution in their conduct of the presidential election. The violation occurred whether or regardless of the amount of election fraud that they may have had, or even if it turns the election. The 4 defendant states are Georgia, Michigan, Pennsylvania, and Wisconsin. Texas filed the suit directly in the Supreme Court. Article 3 of the Constitution says that there is a category of cases which the Supreme Court has original jurisdiction. And one of those categories is controversies between 2 or more states. Well, that's exactly what this is. Now, the Supreme Court has said in the past they may not take all of these cases. It'll take them at their discretion. But this is one the Supreme Court should hear and should be on record. No matter how they decide, they should be on record. Now, here's what the Texas suit claims, and it's, I think, compelling. It's something that bothered me before the election, and we talked about it before the election. The 4 offending states violated the U.S. Constitution in 2 different ways. First, all 4 of them violated the Electors Clause of Article 2 of the Constitution when executive or judicial officials in the states changed the rules of the election without going through the legislature. This is what we were talking about. All these states just had either a judge or the governor just say, oh, we're changing, here's what we're doing. That's against the Constitution of the states and against the U.S. Constitution. You can't do that. It has to be through the legislature. Well, it was ruled on by the local judges, and the local judges said, nope, it's fine. Well, is it? The Electors Clause requires that each state shall appoint its presidential electors in such a manner as the legislature thereof may direct. Now, the reason why this is in there in the early years of our country, the legislators appointed their presidential electors directly without holding a popular election for the president. That changed, obviously, but the constitutional principle remained the same. It doesn't matter whether the state appoints its electors by a vote in the legislature or by the vote of a people. It is still the state legislature and only the state legislature that sets the rules for the election. That way you can't have what just happened. Somebody getting into power, changing all the rules, and now all of the election is screwed up. So when the Pennsylvania Supreme Court extended by 3 days the deadline for receiving mail-in ballots, we said this at the time. You can't do that. It was not a law passed by the state legislature. In fact, it went against that law. The state court changed the rules in violation of the Electors Clause of the U.S. Constitution. Similarly, when Georgia's Secretary of State responded to a lawsuit by entering into a compromise settlement with the Democrats, they modified the signature verification requirements spelled out by Georgia law. That was changing the rules. In fact, the Republicans weren't even involved in that. This one guy, a Republican, met with all the Democrats. They said, this is what they want. This is what we want. And he said, okay, and gave it to them. Well, where is the due process on that one? Also, election officials in Wayne County, Michigan, ignored the requirements of Michigan law and denied poll watchers access to vote counting, while other counties in Michigan followed the law. This violates the Equal Protection Clause. Now, this one is really important, and I don't know how the Supreme Court wouldn't take this on and rule exactly the same way. In Wisconsin, it happened. The administrator of the city of Milwaukee's election commission ignored the requirements of Wisconsin law and directed election workers to write in the addresses of witnesses on the envelopes containing mail-in ballots, while the ballots without witness addresses were deemed invalid everywhere else. That means those ballots were unequal. They had unequal treatment to other places in the state. Now, what they're doing, and these may not change the outcome of the election at all, but everyone should be very focused on this. Because did you hear Maduro won again last night in a free and fair election, and all of his allies won as well. Once you corrupt the system, it's over. We have to have confidence in our system. So now this is a pure question of law. It's not dependent on disputed facts, although the changes, the unconstitutional changes to the election rules, could have facilitated voter fraud. There's no proof, and there's not even an accusation. They don't need a single case of fraud to win. It's enough that 4 states violated the Constitution. So the lawsuit asked the court to remand the appointment of electors in the 4 states back to the state legislatures. Supreme Court in 1892 said the case in McPherson and Blacker, whatever provisions may be made by statute or by the state constitution to choose electors by the people, there is no doubt of the right of the legislature to resume the power at any time. Now, the reason why this is so important is because the Supreme Court knows that 20 years ago, this very case was made about Florida. You can't count the ballots differently in one county than you did in the rest of Florida. Remember, Al Gore just wanted to cherry pick the counties where he was doing well and have a recount. And the Republicans said, you can't do that. You'll recount the entire state the same way. Went to the Supreme Court. They said that that is a violation of the Equal Protection Clause. So why wouldn't they say that this time? Texas followed the constitutional rules. Other states followed the constitutional rules. If other states are allowed to violate those same rules, it's not just a question of constitutional law. It's they're going to hate this. It's a basic matter of fairness.